Good morning, good afternoon, and good night. Welcome everyone to this week's Law Science event. I'm Vanessa Villanueva. I'm a JSD candidate at the University of Illinois, and I also will be the moderator for this session. And before introducing today's speaker, I will briefly introduce the Law Science Project. This is an academic initiative that is coordinated by a group of JSD candidates who share the same belief in legal methodologies, often are understood as a discipline distinct from hard science, and traditionally consisting on doctrinal analysis and normative questions. We aim to change a little bit this perspective through a series of interdisciplinary talks, and to show that legal research can be improved and benefit from scientific methodologies that provide systematic ways to approach questions and deliver falsifiable claims. So if you want to learn more about the Law Science Project, please visit our website or join our mailing list. Now, one of the coordinators will drop the link in the chat. And to continue to today's session, I will introduce the coordinators for this 2022-2023 cohort. First of all, Simonson, he's an SJD at Indiana University Maurer School of Law and co-founder of this initiative. Then we have Patrick Chunchawan, who is a JSD candidate from the law school at the University of Chicago, and Daniel Hefty, who is a JSD candidate at Cornell Law School. We also have representatives from JSD and JSP programs from different universities. And if you are interested in getting involved, we are currently looking for new law science representatives, and you will find the link in the chat as well. So moving forward with today's speaker, I would like to introduce briefly also Florencia Marotta-Wurgler. She is her research focuses on contracts, consumer privacy, consumer law, electronic commerce, empirical studies, and law and economics. She has studied consumer contracts and privacy policies online, such as whether disclosure and information privacy regimes are effective and whether people read the fine print. She has participated in FTC hearings and testified before the US Senate. She is also a co-reporter of the American Law Institute Restatement of the Law of Consumer Contracts and a member of the Scientific Advisory Board of the Max Planck Institute for Research on Collective Goods, and a former member of the Board of Directors of the American Law and Economics Association. She serves as the director of the Study Abroad program in Buenos Aires at NYU School of Law, where she is also a fellow at the Engelberg Center and an affiliated faculty member at the Birnbaum Women Leadership Network. Today, she's going to give us a lecture on empirical legal research using data to create a robust research pipeline. So without further ado, Florencia, the floor is yours.
Thanks, Vanessa. Thank you for such a kind introduction, and thank you for the invitation. As I said, I'm always delighted to talk to people doing empirical work. So the topic is empirical legal research using data to create a robust research pipeline. Oops, there we go. So why do we do empirical research? And this matters because this is what drives how we gather data and what we do with it. So of course it's to understand existing practices, but also to unearth new questions. I mean, sometimes descriptive studies are I think, wrongly perceived as not complex enough, but descriptive studies are hugely undersupplied, and describing an area of the world that's important documenting reality in a way that is meaningful and informative is A, very hard to do, and B, extremely helpful, because first of all, you can answer a whole set of new questions, but this is how new legal fields are created. So I think that there's a lot of low-hanging fruit when it comes to descriptive work. So we get to document reality. It's a great opportunity. There are no wrong answers. Many times we have a certain hypothesis in mind and we do all the work, and whatever hypothesis we had in mind don't really pan out, and we have to kind of start from scratch. If you identify the right area to explore and document, there's no wrong answers because you're describing the world as it is, and that's very meaningful. People doing comparative work, I think, are more versed on the importance of this, but this is true in every single field. And of course, Why? Because some questions can only be answered empirically. Sometimes there's like this huge, vast amounts of theory and people thinking that, certain things work in one way or another way, or there's a right or wrong way. And many times the way in which these debates get addressed or answered or changed or modified is really through empirical work. It's like, well, maybe the assumption that you're using about how certain things work is wrong, and you get to document that, and then you steer the literature forward. So there's lots of different things, questions that can be answered empirically. It's a great way, which I think the reason why I got into empirical legal work is because examining the effect of laws on behavior is the only way of seeing whether a particular type of regime is doing what it's intended to be doing. And for me, that's very important. I mean, we have a lot of regulating by anecdote, and that's a problem. I think a systematic analysis of first of all, how the world works in order to understand whether there is anything that needs to be addressed, and also how the existing laws affect behavior or reach their desired outcome is also extremely critical, not only for research, but also for the real world, which I think is important. Examining the effectiveness of legal rules or regimes, and of course, to examine the factual basis of a large theoretical literature. So empirical work is both useful for the real world, for very practical questions, but also very much embedded in theory. And you need both, right? You need to have some type of guiding principle when you do empirical legal research. And there's many different ways and you can answer a question, and having a particular set of priors is actually a great way to motivate the work going forward. And of course, to identify causal effects, right? So through experiments, either natural or field or lab experiments, causal effects are a tricky, ever evasive type of inquiries, but they're extremely important, and we can land the right empirical design. It's a terrific thing. And the other thing that I'll talk about today is, in addition to all of this, empirical legal research is extremely helpful in helping create a robust research agenda. You never run out of questions. Like examinations of data just generate more questions that they answer, and this is not a bad thing. It's a good thing, because that means you won't have enough time to analyze all the things that you'd like to analyze. So I'll talk about some strategies for empirical legal research, and I'd like to leave some room at the end to talk about your projects and some of the things that I discussed. First is so the first approach is like from data to questions, right? So so as I said earlier, we talk about descriptive work, and you can say, well, the right kind of descriptive word, not all of it, is always valuable regardless of the findings. So you can think, okay, I'm going to explore this particular practice, or I'm going to explore this particular area of the world or area of the law, and I'm going to document what's happening, and that's going to obviously raise some questions that can lead to follow-up work, or can basically touch on some existing theoretical work. So you always, whenever you do something, you always need to think about how is this going to relate to questions that matter, right? Every question has to answer. I always tell my students when I teach a writing seminar, the so what question. When you do a project, you have to answer, well, so what? Why would people care to know the answer to this question? Why would people care to learn the facts or details about this particular area of law or behavior? And if you have an answer that's meaningful, then you have a question. And it's a great platform to develop a research agenda. And I'll use some examples. The drawbacks are that creating a new or supplementing existing data sets can be time consuming. Sometimes I'll spend 1 year or two just in the data gathering mode. And by data gathering, I don't mean just gathering the data, but it takes me a long time to develop a coding methodology so that what I find can be analyzed in a way that is legally and economically meaningful. It's you can't just like grab data and not think about how you're going to code things. And then there's the next approach, which is the other way around, which is from questions to data. So you have a particular question that you want to answer, and then you go out ahead and get the data for it. So it's great because the research design is already there. It's not that you need to, crack your head figuring out what you're going to do with this. It's much more expedient. And you can immediately join existing dialogues, right? There's already a debate. You're already joining a conversation as opposed to creating a new conversation, which can be extremely valuable as well, but it might take a little bit longer. Of course, you can get the wrong answers, in which case you might need to backtrack or reformulate, or you might join a very crowded field. When there's a publicly available data set that everyone's exploiting, there's a bit of a tragedy of the commons, right? Like the research gets overexploited and the questions get very narrow. And I said earlier, it takes the same amount of work to answer a big question than a small question. So it's better to just, go as big as possible, as long as it's always nuanced and meaningful. Okay, so we'll zoom in on data collections, from data to questions. How do we start the process of collecting and coding data? Because we're trying to describe the world. The sample that we collect and the methodology that we use have to be extremely sound. Otherwise, it's just noise or junk. So it has to be, a sample that is random and representative and of sufficient size, that it has enough power to give answers to the question that we want to ask. It can be either hand collected, or sometimes it can be combined from different sources. You don't have to go, from scratch. You can combine things that exist in different fields or things that exist in the legal literature that haven't been used in the same way. And that's terrific. It's like an iPhone, right? Like Steve Jobs just put all these things that exist in the world together, and it's this genius new component. You don't have to reinvent the wheel. But then you might want to ask, does it help you describe an area of the law or answer questions? And then there's a coding methodology, which I take a very long time to develop. When you decide how to code data, right? And I do contracts, for example. How am I gonna, these, thousands of words that appear in a document, what am I gonna do with them? How am I gonna classify them? What am I gonna focus on? How am I gonna zoom in? And what happens with the data? What happens with the stuff that's not there in my coding? Is that going to affect my findings? So the first thing you wanna do, as I said, you need to start with theory and with existing literature. What questions do you want to address? And how will you report the results? I usually start by sketching the tables. The tables that I do tell the story, the tables and the graphs. So and then I write the paper. How am I going to tell the story? Sketching the tables in advance will help you understand the type of information you need to code. So you need to kind of like go on backwards. What do you want my final paper to look like? And then I'll go, of course, you go back and forth because you might not be able to code certain things or find certain things. What are the relevant variables? Sometimes you want to grab more because you don't want to go back and collect more, but you have to make it manageable. At some point, you have to stop. So, and then you need to develop a coding strategy, whether it's laws, whether it's contracts, whether it's any type of resolutions or cases. I'm doing a big study on opinions, for example. So what coding strategy that allows for meaningful, either quantitative or qualitative analysis that has to be unambiguous, right? So what you're coding cannot be interpreted in different ways. Exhaustive, meaning that what you leave out is not gonna, it's not gonna create some omitted variable bias. Coding that allows you to measure what you want to measure. And of course, what are the control variables, right? What else might be going on that you might need to keep track of? Is it time? Is it what other people are doing? Is it other laws that might have passed? All of these things matter as well. And then you need to think about replicability, right? You're gonna make this, ideally, you want others to join the conversation. In order to do so, your work must be replicable, right? You need to make whatever it is that you're doing has to be done in a way that has internal logic, but also can be done by others and shared. And keeping a detailed log of every step and definition is extremely important. Of course, being consistent as well. So then, great. How do you do this, right? So the first thing is, sometimes you don't have to create your own data set. You can use the data used by other scholars, particularly if you're joining a debate. They're publicly available. They're posted on their websites. Their universities have access to lots and lots and lots of different types of databases. Like marketing departments are amazing at this, they exploit this, or other political science departments also have other types of data sets available. I have colleagues that develop data sets. So Kevin Davis and Steve Choi have an amazing corruption index data set that they help refine from existing data sets from the World Bank. So there's lots of existing data sets. So you can use data used by others and ask new questions, or you can have new or better data. You can identify. So as I just mentioned, my colleagues, Kevin and Steve, they have a series of papers where they basically identify the shortcomings of existing data sets. Like, wow, this was clearly not coded by lawyers. All of these variables measuring certain legal aspects of how they affect corruption are wrong. And they have really important papers where they chart new paths going forwards, by basically making this new improved data set publicly available and answering questions themselves. There's government, there's think tanks, there's after the financial crisis, the CARD Act made the Fed release all sorts of financial information from credit cards and other lending institutions that have been used by economists, for example, consulting firms and subscription-based services. And then coding, there's established coding mechanisms where you can improve them, right? Again, all of this is up for grabs, which is fantastic. And now I'll use as an example some of the work that I did some years ago about standard form contracts. This is an example of from data to questions. And so we'll start with that, and then we'll explore some additional pieces. So how do we use the data that we collect to understand the effectiveness of regulation? So I'll talk about from questions to data. And then we're going to talk about, in this new world of ChatGPT and machine learning, how do we increase scope and scale, expanding to other areas and maybe developing machine learning methodologies, and how to combine the old and the new. I mean, we still, legal analysis, at least the very complex ones, still exist in very gray areas, and context matters a lot. So here's an example. So I use software license agreements. I have a series of articles on that. And the reason why I decided to study software license agreements was, well, one, I was very interested in understanding what's in a standard form contract, what's happening with contracts. Most of the literature on contracts, as opposed to corporate law, was theoretical when I started working in this area. Software license agreements were all available online, so it was just easy access. And turns out there's very rich contract, and they were a hot topic a while ago. So I just thought I'll work on that. So just a happy coincidence. So the first question that I studied was this big controversy over these pay not terms later contracts. And usually when we think about the bedrock of contract formation is mutual assent. It's this voluntary agreement between two parties. So the whole point of having, state-backed enforcement of contractual agreements is this idea of assent. In order to have assent, you need to know what you're agreeing to. So when these types of terms in the box started popping out, you remember, like, by opening this box or by opening this package, you're agreeing to the terms of the agreement. Now it happens all the time, but at the time it was, and it's still controversial. Usually you'd imagine that before you pay for something, you need to have access to the terms. And there was a very big controversy around that. And I thought, well, in order to see whether these delayed disclosure of terms are exploitative or bad, we just need to look at them. It's really an empirical question. There's theory on both sides. It could go both ways. So let's look at that. So the question arose from a descriptive study that I did a while ago, a little bit earlier, on just basically analyzing the content of standard form contracts. Like, what's in there? And how do they compare across markets, and how do they compare across firms, and how do we understand them to be? Are they excessively consumer friendly or excessively seller friendly? It was just a paper that just talked about the contents of the contract, and that's an example of a purely descriptive study. So again, the motivation was over 100 law review articles debating whether pay not terms later contracts should be enforceable. There were legal opinions with conflicting outcomes. And I said, well, I have this database of standard form contracts already, and it's coded across like 32 dimensions. All I need to see is whether the contracts that are hidden are worse than the contracts that are available. And that will help me answer the question. And that's what I did. There's this big case in 1996 that became, quite hated by law professors, where Judge Easterbrook said, you know what, notice on the outside, terms on the inside, and a right to return the software for a refund if the terms are unacceptable seems totally fine to me. Why? Because sellers are constrained by reputation. You can always return what we don't like. Nobody reads, but these very diligent, informed buyers will discipline sellers. And so business as usual, no big deal. those who were against it, despite saying this goes against our whole understanding of contract formation. But if we want to talk about economics terms, higher comparison costs, weaken competitive forces. Why? Because they need to buy the product and return it. And that might actually make these terms, the ones that are hidden, much more seller friendly. Sellers are going to take advantage and exploit this high cost of return to include bad terms. And that killed a ton of initiatives to regulate online contracts, including the UCC Article 2, revisions to ACC Article 2, the Uniform Computers Information and Transactions Act, and some ALI proposals. So it was actually a big deal. So the way I thought of it is, well, whether the worst for buyers is an empirical question. We have theory on both sides. Let's just see what's happening. So let's do this in the context of software sold online. Using the sample from this previous paper, again, as I said earlier, one paper can help you create another paper. You don't need to do all the same work again and again and again. And just coding on extra variables. All I need to know for this paper is to know where these terms are located from these firms, right? So it turns out that at the time, many firms, including their contracts on the website, and many firms didn't. You had to actually buy the physical software, and actually ended up buying a ton of terrible software just to get the contract, including terrible screensavers and things like that. So the sample consisted in 515 software end user license agreements from this data set called the Software Industry Directive. They spanned 114 different software markets. So again, you want to make sure, again, when we're talking about control variables, what might affect what's in a contract? Well, firms in different markets might have different terms, so we need to control for that. And they belong to 468 companies. 40% of the products were targeted to consumers and 60% to business users. They might have different contracts. So we need to separate those out, and we try to be comprehensive and representative. Turns out that about 52% of the contracts are PNTL, pay now terms later, meaning that you have to buy the product to get the software, and 48% are accessible on the web page. But of course, accessibility varies, right? We have these browse wraps that are just kind of at the bottom of the page, or it requires many links to access. And then there are those that you need to go to the checkout page, and even if you wanted to avoid the contract, it's right there and you can't avoid it. So a click wrap. So I said, okay, great, let's just focus on this disclosure variable, which is the most important thing here. And we'll just talk about the pay now terms later contracts and then accessibility. But then you have these, contracts that are very long, and you need to make meaningful comparisons across contracts. How do you do that? How do you compare one contract relative to the other? And what I thought about is, well, we need to create a neutral benchmark. So we created this overall EULA bias. I don't know why I talk about we so much. It was me at the time. I work with co-authors a lot, so I'm used to we now, but at the time, it was just me. So I tracked 25 common terms that allocates rights and risks between buyers and sellers. And what I did was, if a term is more pro-buyer than the default rules of Article 2, I give it a +1 point score. So basically, if the software is sold with no contract at all, the court will use the default rules of UCC Article 2. So any deviation from those rules is a great way of determining whether the term is pro-buyer or pro-seller. You can use this for any type of empirical analysis that doesn't involve contracts. If the term is absent or matches the default as a 0, if the term is more pro-seller than the default rule, it gets a -1 point score. So then I add all those terms and I create this index, which is extremely coarse, but extremely transparent and replicable, and it allows for meaningful comparison. You might be wondering, well, but there's some terms that buyers care more about than others, and you might be counting all of them the same. I'm like, yes, and then we divide in subterms, and we can find ways of addressing that. So imagine a EULA with only 3 terms. The first says that the seller is going to give some updates and upgrades and lots of great free goods for 60 days after purchase. The default rules give buyers no such rights, so you get a +1 point score. And then there's some disclaimers of consequential damages that are available to buyers under the UCC. This gets a -1 point score. And then there is any action arising under this agreement shall be filed only in courts of Idaho. Again, the consumer has a right to file anywhere where they're located, as long as there's a minimum contact. So this is more restrictive than the default rules. So So this particular contract has one positive term, two negative terms, and then 22 terms that match the total because the contract says nothing. So the overall bias of this contract is -1. So I do this for every single contract. So each contract now is reduced to a score. Now, I divide them in subcategories of related terms so that we can say, well, let's see how the contracts compare on the warranty dimension or the disclaimers of damages dimension so that we can zoom in on things that are perhaps a little bit more meaningful. So what do we find? That pay now, terms later EULAs are not worse for buyers. In fact, they're a little bit better. And what's worse is that the click wraps that are in your face that you need to click on, I agree, those are the ones that have the most bias of all. I mean, you can argue that half a term is not in any way economically meaningful. It's statistically meaningful, but not economically meaningful. But the key question is that the accessible contracts are not worse. Click wraps are on average one term worse than the rest of the pay now terms later contracts. And when you think about it, it makes sense. If I am a seller and I'm going to include a particularly egregious contract, I know that nobody's going to read it. So I'm just going to make sure that everybody clicks on anything and everything. And so that when I get sued, I'm going to say, look, I disclosed, half the people are not disclosing. And here I am, I disclosed. So the problem is not in the hiding of it. If there's a problem, it's clearly not the delayed terms. If there's a problem, it's in either all the contracts or the contracts that are more saliently disclosed. So that was fun to answer that question. So another example is, so I use the same data set of, using this very simple methodology to answer the question of, well, at that point, I gathered data on location of terms. What if I look at different, the doctrine of unconscionability cares deeply about whether the seller has marketing power. Wouldn't it be interesting to see if sellers use their market power? Did I say marketing? Sorry, use their market power in addition to extract higher prices, which is what the theory would predict, to also include worse terms. So I just looked at I found market share data and estimated the Herfindahl-Hirschman index, the HHIs of each particular market, and I sought to examine if sellers in more competitive markets offer more consumer-friendly terms than sellers in less competitive markets. The answer is no, but the price does matter. The price is higher. So that was another paper. Huge deal about arbitration clauses at the time. Dispute resolution clauses strategically designed by sellers to take advantage of consumers. That resulted in another paper. And then I wonder, and then it was a more mapping the data with a theory. To what extent do online contracting practices conform to existing theories on consumer behaviors? So we got a couple papers on that. So what I'm trying to show with this is, it might take a while to create a data set, and it might take a while to think about how to tame it and analyze it, but you can have a pretty strong research agenda just with this one data set of related papers that matter, that help you map a more interesting picture. Then I started focusing on consumers, like, do people read, do disclosures work? And then, started focusing on the effects of regulation. So it can take a while to get a sense of what's happening in a particular area of law, but you can do so with one-time investments in terms of data. So the next example I'm going to move on is work that I've been doing more recently, which is the online privacy policies. What did I get into privacy? Because it's regulated by contract, which is bananas, because nobody reads this. So here I am, I study fine print, and I'm thinking, all of these transactions involving personal information are really mediated through this little standard from contract that people pay no attention. We can talk about GDPR in a minute. So the lessons from developing an objective, replicable, meaningful methodology to co-standard from contracts can be used in other domains. Privacy has been at the forefront of many regulatory debates, and it's an area that's mostly, as I said, governed by contracts and some regulation. So first, some questions, right? So why am I interested in privacy policies? Well, first, are they shaped by market forces? Why? So again, this is purely descriptive. What's in them? And to what extent do we see any type of evidence of market forces in these things? Because if they're shaped by the market, then we might not need regulation. And then we want to make sure do the regulations are having any kind of effect on the practices that we see? Why does these questions matter? Again, always have this so what in the back of your head. If there's something that you take away from this talk, I hope is a so what. There's tons of regulation on privacy stories in the news. It's everywhere. We're increasingly concerned by it. And there's been little empirical literature on information privacy that's changing, which is great. So the model in the US has been one that relies on contract. It's notice and choice articulated by the FTC. The idea is that firms disclose their information practices and privacy policies, and consumers read them and go to the firms or to the services or entities that have the information practices that they want. It's fantastic in theory. Obviously, a little introspection will lead you to think that this is complete fantasy. Nobody reads privacy policies. And then there's these regulatory guidelines where the FTC tells firms, you got to adopt these best practices, and if you don't do it, we're going to tell Congress to regulate you. And then in order to give firms a little bit more of a stick, the FTC uses Section 5 of its Deceptive and Unfair Practices Act to bring actions against firms that are either violating their own terms or engaging in what they deem unfair practices, so bad security measures and so forth. So how is this model working, and how does it compare to top-down models like GDPR? These are questions that I think matter. Some say well, some say badly. Some consumer advocate says the FTC is incredible, and the FTC does do a lot, but it's very limited. But we don't know because there's been little systematic examination of current practices. And this matters because GDPR has taken hold. A lot of GDPR is based on disclosures, and a lot of GDPR is being exported into the US. So again, large sample study and story of privacy policies. What's in them? Are firms embracing the current guidelines? Is there evidence of any type of market forces? And why do we care? We want to inform current regulatory debates, understand outcomes of the current regimes, and see the extent to which market forces might be shaping privacy policy. So again, this is one that I did on my own. 261 privacy policies. Do you see a theme in this? Different question, different area, not reinventing the wheel. Let's focus on a meaningful markets, wide adult markets where people are arguably aware that they're giving information, because we want to give these firms, these policies, the benefit of the doubt. Like, look, if in these markets where you're like a dating site, we're obviously sharing your information. If you're not reading the privacy policy of this, you're likely not reading it, the one in the New York Times. Adult sites matter because people might be especially careful when doing something that they most generally mean to be private. Cloud computing, why? Because we put our whole lives on the cloud, particularly firms, and it matters. Message boards, social networks, using a representative sample, Google, Facebook, to even your most niche dating sites and so forth. Each policy is graded on dozens of dimensions. So again, relative to meaningful, how do I compare one privacy policy to the next? How do we make sense of that? Well, let's see how they relate to the OECD guidelines, to the FTC guidelines, to GDPR. So there are all of these categories of practices that firms might do. Let's see if deviations from these recommended or required practices are help us not only measure the extent to which firms are complying with the law, but also how they differ. They differ from each other. So what do we see? We have very granular coding, dozens, as I said, of dimensions. So is this policy accessible through a link of the home page? What kind of data is being collected? This is just one page of many. Can third parties place ads that track your behavior? So here we have the Fair Information Practice Principles from '73, the European Safe Harbor of 2000 that Max Schrems got rid of, the FTC Fair Information Practices, FTC Privacy Report. So there's lots of data collection. Only 19% require explicit agreement. A lot of the recommendations have been ignored, and many firms are just silent on things. And unlike the default rules of Article 2 that I spoke to a few minutes ago, there's no default rule of privacy. So if a firm doesn't say that it's collecting information, it's not clear under the US law, we know, and under GDPR, whether the firm is allowed to do so or not. Why? Because there's no default rule and there's no requirement that a firm says. So maybe the California law has changed that. So then we look at compliance with the FTC, and what we see is that about 40% of the contracts comply with, 40% of each contract complies with the FTC guidelines. So compliance is somewhat low. And here we split the sample by markets. We see interesting and intuitive differences in what firms do with the private information of individuals. So the green shades is whenever a policy, is whenever a firm, whether a market is statistically significantly more likely to comply with that particular set of terms than the average firm. And red means the opposite. And what you see is that the firms that do the best in terms of protecting your information are adult sites and cloud computing sites. When you think about it, it makes a lot of sense. Actually, the best contracts of all were the adult sites. They're like written beautifully, simple English. You can pay with a gift card. You don't have to give us any information, even if you don't trust us. So again, sensitive information, people care about it. Cloud computing as well. There's probably a lot of free riding going on in terms of consumers piggybacking on firms doing their due diligence when it comes to cloud computing services. A lot at stake. Firms might care, might want to make sure that consumers are relieved that their information privacy practices are particularly the ones that relate to security, there's business secrets and so forth that matter. And then special interest in message boards, gaming, not so great. So there's some evidence of some market forces at play, which is really interesting, but the overall picture is that compliance with the law, not so great. So what do we conclude from that? We have this large sample analysis of the content of privacy policies. The regulatory model appears to have a pretty moderate impact on privacy policies. It's it's contrary. There are all of these debates that the FTC has a new common law of privacy and has so much teeth. And then you look at the data and you're like, not so much. But market forces are arguably playing a role. So I wrote this up in this paper. But of course you can extend it, right? So here, Kevin Davis and I wrote a paper on seeing, well, let's look at the data, how it changes over time, and see whether their contract is a good model to deal with this information, whether flexibility is good or whether sellers are taking advantage of this flexibility. And then let's look at the extent to which the GDPR has had an effect on these information privacy. So we noticed like this huge spillover effects. When we were reading the 2018 policies, all of a sudden we're like, whoa, there's a lot of compliance going on here, and it's not with US law, and these are US facing contracts. So we just studied, developed some hypotheses and test some existing hypotheses developed addressing this Brussels effect, to what extent, is the EU exporting regulation, and why are US firms complying with this much higher, more stringent standard of GDPR? So that's all using hand-coded data. Now, what happens with these new more sophisticated techniques that allow us to study things in the hundreds of thousands or millions? So how hand coding can be tedious and time consuming. That being said, hand coding is terrific because there's reading the contracts or reading the regulations and getting your hands dirty with whatever it is that you're studying gives you such a meaningful understanding of what's going on. It can never be, you can never just study something without really getting a feel for what's going on. There's just no way. There's some connections that are hard to do. But these data sets can be used to as training sets for machine learning approaches, what we're using with, so all of these coding of privacy policy, we're using to use machine learning, using machine learning approaches to scale up the coding and seeing the limits of machine learning methodologies at the moment. And then we explore automated coding with machine learning techniques, and again, in joint work to understand how GDPR is being enforced on the ground. So one of the things that we did here very quickly is just to create a tool to the anatomy of privacy to annotate and code privacy policies to use as a training method. So what you see here is there's a tool that has the terms of the contract on the left and And on the right, there's a question, and each coder, again, the contract is always coded twice. To you have to highlight the particular part of the contract that you use to answer whether a particular question, here, can you track a cent? And then to answer the question specifically. So with this tool, we map the exact part of the contract that lead a coder to come with a particular conclusion. And then we can use all of this very detailed information to train this on out of sample things. And here, what we do is we scraped all of the GDPR enforcement actions that exist in all different languages. We translate them to English using deep learning, and we used a question and answer machine learning approach to code their context. So you can put, search the phrase obtain consent from what country, from Italy. And again, you need to sit down and read some agreements in order to understand what to code and how to look for things. But developing the tool makes this much easier, and you can scale it. So happy to talk about that as well. Conclusion: empirical analysis can be an effective tool for creating a robust research agenda. Each project becomes a building block for the next set of projects. And again, if you're interested in becoming a fellow at NYU, we have a Law and Economics Organizations fellow, and the application is in January. I look forward to your questions.
Thank you very much, Florencia, for this wonderful presentation. I don't know how we want to proceed, because I think that it's also interesting to exchange ideas on how our projects are going on.
Yes, so I'd love to hear that.
Maybe it will be interesting to each one of us, like, extremely briefly introduce their projects, and so that we can have an uncommon exchange of ideas.
Agreed.
So I will start then, since I'm taking moderator privileges. I'm at the end of my degree. I'm working with empirical methodology, and I think that I'm speaking also on behalf of my colleagues that we could not do otherwise, because Robert Lawless and Jennifer Robinall are here. So we had just to move in that direction, and I'm actually working on uncovering duties of crypto intermediaries in blockchain. And one of the chapters is devoted to structural equation models for latent variables. That's the methodology that I'm applying. So categorical data analysis to uncover the existence of intermediaries. And the product of this project, as you were saying before, that it's a roadmap of how can you draw different inferences from an initial project, is when I was a student in the first year, and one of my colleagues that we did the project together is here as well, we were studying the effect of know your customer procedures into the success of an ICO, of an initial coin offering. And from that study, it showed something that I was not expecting to see, which is that actually intermediaries, as we know, exist in an area that allegedly seems to be disintermediated. So that's why my study started, and that's what I'm doing now. Simon, do you want to continue?
Yeah. Well, for me, I'm working on my dissertation is about Section 230 of the Communications Decency Act.
Oh, not a hot topic at all.
No, just me. and how
what's that section? I never heard of it.
Yeah, the 26 words. Yeah, and I think about how algorithms, the company's usage of algorithms, how courts should conduct a better analysis when companies use algorithms. I've been thinking critically about the legislative intent of Section 230. This draws my attention to originalism and all of those legislative interpretation method. I've been also interested in looking into the impact of my proposal, right? And if I create something that really kind of influences the internet, what would happen afterwards? Which briefly stating, it's how to combat the break the internet hypothesis. Whenever there's something that directly governs the internet, we say that the internet will be destroyed because of that. that part is also where I'm quite concerned of. And I find your research on privacy policies very, very interesting because of my other research agenda on privacy itself, and also the different tools when it comes to internet regulation. Which are the tools that are better? What are, or maybe not better, but what are the tools that are considered as effective, or how can we measure the effectiveness? So yeah, that's kind of what I'm concerned about.
Daniel?
So I mean, my research is very different. I can briefly introduce it, but Vanessa, do you allow me to ask a question then?
Yes,
to,
yes.
You can ask,
Yes.
you can ask the question
Yeah.
before
Okay.
or later.
Yeah.
Okay, because I can transition actually. Like, so what I'm doing right now is I'm trying to give an explanation why the German constitutional discourse is so much fixated on the notion of human dignity, and I try to use the insights of nation studies to. So first, I design a comparative methodology to really tease out what this fixation on dignity looks like, and then I use the insights of nation studies to give an explanation for that. And part of my, so these are like my two questions now. Part of my comparative work is thinking a lot about how the positionality of the comparativist actually translates into unconscious biases in designing research questions and research
that's
setups.
Fascinating. Yeah. Okay.
And so like two questions that I had when, or always have, like when reading empirical work, especially in legal journals, I feel like, as you, I think, laid out very interestingly, there a lot of thoughts go into how you structure your research design. So on every level, you basically have some arguments, some reasons why you framed it this way and not the other. But then when you read papers in law journals, I think I don't see these thoughts written down often. So they explain basically the setup, but they don't explain often why, like what kind of thoughts legitimize that kind of setup. I think that's a bit different in political science literature. So I would be just interested, basically, when you write an article, how do you decide what kind of preliminary thoughts, justifications you had, which you clearly have when designing the research, translate into the article?
Right. So this is an excellent point. So, and I worry deeply about some subjective. I worry about the research where the researcher has a particular prior, and that prior clearly permeates through the work to get to the whatever outcome that results. For me, that's not good work. It's, of course, there's some areas where it's impossible not to have that because we're human, and our experience is what mediates or dictates how we perceive reality. There's no, I mean, let's not get into philosophy about objective reality. But when I do the coding methodologies, I am extremely careful in making sure. That's why I mentioned the word benchmark. People are like, why are you so obsessed with benchmarks? I care about benchmarks because it has to be the most, and there's a trade-off between how meaningful and like, well, you're adding ones and zeros, and that might not, there's particular weight that you might give to things, but when you put a weight, you add certain subjectivity that detracts from making things, from removing yourself from the exercise. And the way in which I do so is by looking for meaningful legal benchmarks. UCC Article 2, right? So how the contract complies with this law, we make it extremely granular so that you can have a 1-0 answer. Is this there or not? Are you or with privacy took forever. Privacy took forever because privacy is such a muddy puddle in terms of what applies and what's not. There are no default rules, and that requires to be a lot, maybe track things in more detail. And I spent a lot in my papers describing how the methodology is done, why we use a particular benchmark to describe things, what's included and what's not included, and you try to be as exhaustive as possible. Why? Because I want to make sure that the reader understands that I want whatever I measure to be meaningful in and of itself. So seeing whether something complies with the law or not is meaningful. And two, to try not to include, well, I try not to have a prior, because I want the findings to speak for themselves. But also I'm very aware of that subjectivity that might bias my results. And I do not want that. I think that good empirical work is a type of work that is that can be objectively measured, and whatever you measure it against has to be meaningful. So that's why understanding the law, spending some time researching, and of course, doing tons of rounds with experts in the fields to say, does this make sense? When I did a paper about learning in startup from contracts with a colleague, Giuseppe Dari Mattiacci, it was a theory about how firms learn and change their agreements. We ended up interviewing legal counsel at firms, because what do we know? We have this hypothesis that sounds cool. Does it match up to reality? And of course, we didn't tell them we're studying learning. Hey, do you learn? Because that would have biased the results. We're like, hey, what makes you change your agreements? When do you revise them? And then let them organically tell you about experiences where they actually experiential learning was a thing. So we could have completely biased those results, but because we're deeply aware of that, we take lots of protections for that not to happen. I hope that was helpful.
Thank you very much. So if anybody wants to jump in, please raise their hands and I can let you present your research.
Yeah, or if you have questions or
but
questions of how it relates to your work.
I've not raised my hand, Vanessa, sorry, but thank you for the talk to the professor. I found it interesting, especially the latter part of the privacy work. Incidentally, I have a week to present my dissertation, and my research is basically on privacy harms.
Oh, great.
And I come from a position that, at least as far as I've seen, there is no empirical work on the breadth of privacy harms, especially coming back to your contract issues, whereby the bottleneck of Article 3 standing, that if there is no injury, that you've not, courts have no answer for it, at least the federal courts, because the demand for the Article 3 standing injury requirement is not in the, it's not required in the state courts.
Yeah, it's not required, but they still get thrown away. It's a huge problem. All of the contracts claims and torts claims, all of them, almost all of them, even though recognizes it, they throw it away. So I agree, it's a huge problem.
So fast forward, the results among many, and like you said, there's more opportunities because my data set is extremely rich, but I just decided to do a positional paper and I intend to have spin-offs thereafter. But the major result is that 60% of the data privacy violation cases are thrown out of court because the claimants cannot prove harm. And many other observations that I make.
Can we talk about offline afterwards? Can you send me an email? Because I'm working on a similar thing and I'd love to cite your paper.
Please, I will. I actually have a paper that was accepted in a law journal for publication, around 2-3 other papers as well. But the major one is in the law journal.
We're working on that with this whole GDPR thing. So that's
sure. I'll send you an email. Thank you.
No, that's great.
Right. Okay. Anyone else? I cannot see hands raised. All right. I had a question, and I think that's going to be the last question because we end up this session.
Yes,
so,
of course.
So regarding, I have actually 2 questions. One that is very concrete, and you were mentioning that you are now experimenting on machine learning, so data mining. I understand that that's what you are using now. And what have you used in the past? Like what software were you relying on for your studies?
Great. So so I always use Stata.
Okay. Yeah.
And it used to be that Stata didn't deal with huge data sets that much, but now it does, and it's fantastic. So I use Stata. All of the machine learning super detailed stuff, my co-author David Stein, who's a computer scientist, he's been doing. I am learning that part. I just basically get it in a Stata friendly way, and I do all of the analysis. but I am a Stata person. I know that there's Pearl and other types of programs, but that's basically what I have used, and I found to be great. I don't know what you use.
State as well.
Yes, great.
And the other thing, because it's social scientist friendly, so
Yes.
it's
Yes.
better than other programs. So the last question that I was wondering to ask you is, like, when you mention about causative studies or to show causation,
Yes.
that's something that has been very debatable, I guess, among legal empirical scholars.
Yes.
Because usually when one explains the effects of the regression and how can we read the regression, we're always thinking in terms of association between variables and correlation.
Always. Yes.
But what is your understanding or your takeaway on causation?
So yes, whenever I do work, and because I do mostly observationals, I'm working on an experiment now that tries to understand causation, but when all of the observational work that I do is association, and you can't ever say, that there's causation that's being established. I think that articles that try to establish causation, in a robust way are hard to come by. But sometimes there's an instrumental variables approach that you can use, and that's controversial. There's experimental work, but then that suffers from external validity constraints. I think field experiments can be fantastic. Natural experiments have been great if you can find them. They can take a lot of work, but so yes, it's kind of like finding a unicorn, but if you find it, it's great. So I'm not saying don't stop looking, but don't just put all your eggs on that basket. Speaking of like animals and unicorns and eggs, but that's basically where I am. And it doesn't have to be a causal study for it to be meaningful and valuable at all. I think it's really important to be hyper aware of how much you're contributing and what it is that your paper is doing, and to never, ever, ever oversell, but also never undersell. Be very careful, very forward about all of your contributions. I think papers usually become problematic when they overclaim. Overclaiming is a big problem. And it's as long as we don't overclaim and you're just very precise about what it is that the contribution is, and the contribution survives the so what question, it's fine, even if it's not a causal story. But since we're talking about doing empirical work, I had to have a line on causal stories.
All right, so thank you for joining today's session. I think that we can have like 1 minute for taking the picture with all the participants together.
Okay, send me the picture. Sounds great.
Yeah, please turn on your camera and we can take a picture together.
Okay.
All right. All right. So, okay, I'm waiting. Okay, cool. 1, 2, 3. All right, I'm going to take another one. Wait a second. One.
This is the first Zoom picture that I see. Okay.
Yeah. Yeah. 1, 2, 3. Fantastic. Thank you.
Thank you. And please consider this an open dialogue. If you have any follow-up questions or anything, I'm happy to do so. And for those of you who are doing privacy, there's going to be there's a whole privacy panel in this May 22nd conference, if you're interested.
Okay.
Lovely to meet you all. Fascinating projects. This is what I love hearing to what you're working on, and stay in touch. And thank you again for the invitation. It's been a wonderful Friday morning.
Thank you to you, and we hope to see you soon. Thank you to all the participants, and see you in 2 weeks. Bye-bye.
Bye. Thank you.